It is a privilege and a great honor to be called upon to offer my reflections on the theme Minority Rights and Democracy in India. On this important annual event, and at a time when societies across the world are trying to find a path through this thicket of minority claims. So let me paradoxically begin by recounting a small episode that took place in Switzerland about 10 months ago. In the town of Therwil, with a population of not more than 10,000 people, in the canton of Basel in Switzerland, a handshake was offered and it was declined. Two young boys, brothers aged 14 and 15, refused to shake the hand of a teacher, a woman, on the grounds that it went against their religion, to touch a woman that was not a member of their family. This request for exemption against a common cultural tradition in Switzerland, where the teacher greets each student with a handshake at the start and the close of each class, was accepted by the school. In fact, in a gesture of conciliation and seeking to balance the different norms, the majority Swiss norm of shaking a hand and the minority immigrant norm of not shaking a hand, the local authorities ruled that the Muslim boys would not be required to shake the hands of the teacher of either gender, not male or female. They would instead greet the teachers only verbally. This was a concession available only to the boys. The other children had to shake hands. Nothing happened for 3 months. 3 months later, a television like our television, Breaking News, picked up the story. And very soon, there was a controversy across Switzerland. It was seen as an unacceptable solution to a settled national tradition. It was held to be discriminatory. It was regarded as the thin edge of the wedge, which would bring in its wake more requests for accommodation, deemed to be morally regressive. If the aim of the school and if the education authority in the town was to integrate the new residents within the wider culture of Switzerland, then this compromise was seen as a backward step. This was the debate in Switzerland. It's still going on. Now, I have chosen to narrate this very innocuous story, seemingly very minor, to illustrate the challenges that minorities pose to democracies across the world. Minorities assert difference. Minorities seek acceptance of their cultural claims. Minorities seek to conflate religion and culture. Minorities draw on moral reasoning. Take it to a higher level. Minorities draw on moral reasoning, on which all constitutions are based, to make their claims for differential treatment, doing so on grounds sometimes of theological interpretation and sometimes from a smart political calculus. Minorities across the world are causing intense political churning, unsettling tradition. In France, we are having this whole debate on what to wear. Australia, how to deal with the lost generation, the stolen generation. Bangladesh, bloggers being killed. Pakistan, issues of blasphemy. In fact, if we look across Europe, we will see turmoil because Europe doesn't know how to enter its own future. And demagogues such as Trump in the United States blame it on minorities. The minorities are to blame for a lot of the national problems. The claim that minorities make are challenges to the ideas of the nation and to the place of the plurality, to the idea of a plural nation. This we must recognize. Minorities demand a changed idea of the nation, and they demand the idea of a plural nation. Over half a century, nations across the world have responded to minority claims in a variety of ways. This, I think, is very important for us to recognize. If we look at Bosnia in 1990, 8,000 Muslim men were massacred because of this question of difference. If you look at Iraq, northern Iraq of the current times, we see what is happening to the Yazidis, sexual enslavement of the women, and because they are seen as coming from the devil. We are reminded of the persecution of the Ahmadiyas in Pakistan. We hear of the suppression of the Kurds in Turkey. In North America, there is a tension in race relations between the African American and others. And for half a century, we have had to deal with this discrimination of the Palestinians by the Israeli state. These are few examples of how societies have dealt with minorities. These examples range from genocide to exclusion to suppression to intimidation. In recent years, Europe demands assimilation of minorities, and Switzerland is demanding integration. I'm taking these very key words because around these key words an entire history can be built. So it ranges from genocide, which we saw in Bosnia, to integration, what we are seeing in Switzerland. Now, as the world struggles, and it's important, so let me repeat this. As the world struggles with working out the moral, legal, and social terms of the majority-minority relationship, India's engagement with this question through the last 70 years constitutes a valuable intellectual resource. Let us appreciate this fact. There are many other issues on which India has built over the last 70 years a body of complex arguments which are now available for global scrutiny. In fact, as I want to argue, India can be the teacher of the world on the issue of minority rights. In this history of 70 years, the demands of the troublesome minority, on which India is developing a whole strategy of accommodation, which is valuable, the terms have to be continuously renegotiated. We have done that through a range of issues, from divorce to dress, from food to fatwas. In fact, very recently, there was a controversy in the Supreme Court itself when the Honorable Chief Justice of India and his learned brother judge had a disagreement on the holding of an official event of the court on Good Friday, an important day of fasting and contemplation for Christians. The Chief Justice wanted to have that function, saying, I don't recognize holidays. And the judge said, but it's an important day for me, I will not attend. This became a national controversy. In India, even on national holidays are issues of minority engagement. In fact, we must appreciate, this is very, very important, that I don't think there's any country in the world that recognizes religious holidays as national holidays. And this is done because these holidays belong to the whole nation, not just to the community. That is why they're called national holidays. This must be appreciated. This is my second observation, that the Indian story of 70 years is a story in which the relationship between the majority and the minority is both a fixed relationship and a fluid relationship. And this has to be continuously recalibrated. A vigilant democracy regularly revisits the terms of the relationship. India has done so in imaginative ways. And in this process, it has created a body of ideas which is available to the global audience. How do I, as a student of this area, invite you to look at the Indian story? There are 4 dimensions in which you can look at the Indian story. You can look at the Indian story by looking at the laws. You could look at the Indian story by looking at institutions. You could look at the Indian story by looking at policies, all of these relating to minorities. And you could look at the Indian story looking at the public discourse. Let me start with the laws. We can go to the debates in the Constituent Assembly. I mean, some of the finest debates on the Constituent Assembly took place on this question of minority rights. In fact, it's an amazing story that at a time when India was partitioned, at a time when the nation was struggling with the violence of partition, thousands of people were being killed, millions of people were moving from one region to the other. People in the Constituent Assembly were arguing for minority rights, even though the dominant mood at that time was national integration. There was a fear that if we concede minority rights, the nation had just been divided on minority claims. Would fall apart one more time. There was a fear. There was a fear that if we conceded minority right, national integration would suffer. There was a fear that there would not be the same loyalty. This was expressed from K.M. Munshi to even Rajkumari Amrit Kaur. But when they finally came down to passing the protections for minorities, we have Articles 29 and 30 being passed. This was well summed up by Reverend Jerome D'Souza, who's no relative of mine, when he stated, he says, absorption in the sense of cultural or religious absorption is something against which it is necessary for us to guard. The strength of this land will be based upon the strength of individual members of different communities. and they will not achieve their full strength unless they base themselves on convictions and ideals which are at their very own. Cultural autonomy, for which I am pleading, and which has been promised as far as it is not inconsistent with national strength, even though it may appear in some sense to be opposed to national unity, is still consistent with it. I think this sentiment of Reverend Jerome D'Souza is a sentiment that I think must be repeated over and over again. Give concessions to the minorities, because by giving concessions to the minorities, you're actually strengthening the nation, not weakening it. Three key ideas emerge from this. One, that cultural and religious plurality is the asset of a nation and not a threat. Two, that cultural autonomy must be allowed so that individuals can develop their personalities within their own cultural resources. And three, that this should be given not just statutory status but constitutional status. The second dimension of the Indian resource is the emergence of the growth of institutions such as the National Commission of Minorities, the National Commission for Minority Educational Institutions, and the Ministry of Minority Affairs, the state commissions, etc. If you look at the landscape of the institutional landscape of India, we see many institutions have emerged, and this is extremely important. These institutions may be weak, they may be strong, there may be moments of ascendancy and moments of decline. I don't for a moment wish to discount that fact, but I want to appreciate the fact that we have these institutions in the public domain. As a democratic theorist, I want to state that a democracy gets deeper when its institutional landscape gets more dense, when there are many more institutions to regulate social and political life, because this is the strength of a democracy. What I want to say is that the concern of minority rights now has two bodies of arguments. One is the cultural autonomy argument, the other is the development argument. The development argument is a rich argument which goes into all groups that are disadvantaged, not just minorities. I want to focus my argument on the cultural autonomy argument because that's the harder argument. The harder argument of how can we give minority rights, because the claim is one of cultural autonomy. This brings me to the fourth dimension of the Indian resource. I've said something about laws, I've said something about institutions, I've said something about policy. These can be mined. I've only flagged them here. I cannot discuss them exhaustively because it's a vast literature. But I want to spend more time on the fourth dimension, the dimension of public discourse. I mean, the kind of debate that's taking place in Switzerland, taking place in France, taking place in Germany, taking place in the United States has taken place in India over the last 70 years. And it's rich. It's rich at every level, from the pragmatic policy level to the philosophical normative level, and I will show you by a discussion of one such case. Now, it's important for us to remember, as a democracy deepens, as more groups enter the public domain and make demands on the politics has to respond. And in that process of responding, conflict situations emerge. In that process of responding, through these conflicts, ambiguities will emerge. And it is the task of us to respond to these ambiguities and to these conflicts, which we have done. We've seen this in recent weeks in the whole controversy and debate about temple entry. You know, the Shani temple in Ahmednagar by the Bhumata Mahila Brigade. We've seen this across India in the formation of the Auraton ki Shariat Adalats by the Bharatiya Muslim Mahila Andolan. Civil society groups are emerging and beginning to challenge the public discourse and traditional cultural practices. We're seeing this in the debates among the Dawoodi Bohra community. I'm talking about issues that we must all discuss and confront. And these generate debates on whether, these challenge Article 25, Article 26, whether they come from Article 29 or they come from Article 30. In my discussion now, I shall focus on one dimension. I shall focus on debates in the public domain, because they are very, very interesting and crucial. But before I do that, let me state my position. You must, I've often been asked that you do a very good map of a series of issues, but what is your position? My position is very clear. I think when such issues emerge, I think I value it. First of all, I begin by valuing Indian pluralism. I think Indian pluralism has emerged through a long century of interchange and therefore has produced a landscape which is unrivaled in its diversity of religions, philosophies, languages, scripts, literatures, festivals, cuisine, dress, etc. And to create what is called the civilizational state of India. This diversity, other than being an expression of human ingenuity and its engagement with its ecology, offers us, and that is my point, this diversity offers us a diverse way of living together. A diverse way not just of living together, but if I want to be morbid, of even dying. So even in death, Indian diversity expresses itself. We have rules about who will be cremated, who will be buried in which way, who is eligible to be buried in a crematorium and who is not. Indian diversity covers the whole span of life and death. Now, as the normative landscape changes in response to social movements, in response to new perspectives on rights, demands arise for a change in the boundaries. While structures of traditional authority rest on such demands, the modern constitutional state is required to respond to it. I want to return to the debates in jurisprudence on personal laws, where you get a very good example of this demand for changes in the boundaries. There are many aspects of this extensive literature on personal laws of different communities in India, especially of Muslim personal law, on which I shall focus my analysis. Now, I shall comment on this as a political scientist, not as a lawyer, not as a religious scholar, but as a political scientist. And therefore, the first question that must be addressed is, are these laws which come within the domain of religion, or are they laws which are eligible for secular intervention? The court's interference in a religious dispute, even though it is between husband and wife, would then be considered illegitimate if this was purely and essentially a religious matter. In the Indian debate, the attributes of religion are described as the following. What constitutes religion in India? And if you look at the various legal debates, it ranges from doctrine to ritual, to observances, to ceremonies, to modes of worship, to institutions. Those who resist the court's intervention cite all these grounds for not having the court to interfere. The second argument that is put forward by those who resist the court's intervention is that these are divinely ordained laws, and therefore a secular institution has no right to override a religious law. Only religious authorities who have a training in the scriptures and who have studied sources of religious tradition, are skilled in the arts of religious interpretation, and are qualified to adjudicate such disputes within the zone of religious practice. Secular institutions are both unqualified to interpret scripture and would be guilty of overreach, particularly if they use the coercive authority of the state to implement their position. The third argument, and this is also an important argument, says that the court, by intervening in religious practice or religious tradition or religious interpretation, is beginning to define the domain of what constitutes a religion, and this is unacceptable. Courts cannot say what is religion. What is religion is to be determined by religious authorities themselves, by the community themselves, and therefore the court's intervention is unacceptable. There is a fourth argument, that if the court is trying to enter this area and therefore look for a uniform system on the basis of which it will impose, it is going against the tradition of legal pluralism, which today is the tradition, a growing tradition all over the legal world. And therefore, we are moving in a retrograde direction. Now, all these arguments are valuable. Now, there are two principles of conflict here. The cultural autonomy on the one side, and religious freedom, and that of gender justice and equal citizenship on the other. Most of the cases that appear before the court are cases that have to deal with gender justice and equal citizenship. They come from women who feel that they have been they've been treated unfairly and unjustly, particularly by traditional structures of patriarchy. You can see that in the current case of triple talaq. Now, responding to these controversies, as I said, we have conflict points, we have ambiguity points. Responding to these controversies, people have responded in two general ways. One way is to look for alternative interpretation. So you create a Mahila body that will interpret the Sharia, and they will say, they will give you an alternative interpretation. So you will live within the tradition, but give an alternative interpretation. So that's one possible way, that's an interesting way. Another way is don't get into the core of the problem, but deal with the ecology of the problem. So you deal with family laws, you deal with workplace laws, you deal with other laws, so that you create a less hostile environment in which the individual is located. My position is quite unambiguous. I believe the court must intervene. I believe the intervention, but this is my caveat. The court must intervene, but it must intervene in the last instance. I'm creating a conceptual maneuver, the idea of the last instance. Justice must first be attempted within the cultural community. And when the victim fails, only then, and when that approach fails, only then should the victim approach the court. I use the idea of the last instance to acknowledge the importance of religious freedom and cultural autonomy. I think it is important for us to recognize religious freedom and cultural autonomy. And so therefore many of these arguments I want to defend. But I also want to ensure that gender justice and equal citizenship is also promoted. The idea of the last instance, not the first instance, is to give the community an opportunity to dispense justice, to reform itself, and align its practices with the new thinking in the public domain on individual rights and justice. If such reform is not forthcoming, then the court will have to step in to provide justice, to push that society and all communities within, which is happening. You may not fully appreciate my argument, but if you begin to look at cases in high courts right across the country, the community is being pushed towards accepting this idea of recognizing how individual rights must be aligned with cultural and group rights. So not only must we argue for minority rights against majority tyranny, which is the thrust of what we do in fora such as this, but we must also advocate the rights of minorities within minorities. And the court's intervention is one such strategy of achieving this. On the other side, so therefore, if freedom is about how we worship, what are the rituals we will follow to be made by ourselves, who is the court to tell us that Santara is suicide? Very fair argument. On the other side, on gender justice, they will say, what is this last instance? So the woman must remain a victim for a long time till she gets justice, first rights within the community, which is a patriarchal community. So how can we ask her to suffer the injustice till she decides that no solution is available within the community? I can only go to the court. The last instance, in a sense, penalizes the victim. I see no other way out. I see the doctrine of the last instance as the only way in which we can get both gender justice and religious freedom. It's a difficult road. I'm not saying it is easy. And unless we use fora such as this to generate that debate, it's much easier for us to sort of cover over the hard questions and look for sort of political solutions. But that's not what we are in this game for. We have to ask the hard questions. How do we combine religious freedom with gender justice? And I think perhaps I'm willing to abandon the idea. The doctrine of the last instance helps you through. We see such examples in our legal system right through. I mean, it's even though in 1986 what was at that time considered as a regressive act, the Muslim Women Protection of Rights of Divorce Act 1986 was passed, and all activist groups said this is a regressive step. The judgments of the courts since then have been extremely progressive. Two words in Article 3.1 of the Act have been used by the courts, two words which are reasonable and fair compensation, have been used by the courts to actually give very radical. So even though Section 125 has been overridden by the MWPRDA Act 1986, and Section 125 gave women who were rendered destitute 500 rupee compensation, courts are giving compensation in the tune of lakhs of rupees, even 2 lakhs of rupees within 3 months. We are witnessing, that is why I'm saying we must ask hard questions. It's not easy. It's not easy to present such questions in public fora, but we must ask hard questions because there is a process of juridification taking place, and the courts are beginning to determine this. I was very serious when I said India can be a teacher of the world. I would ask the Swiss authorities to look at the judgment of Bijoy Emmanuel versus State of Kerala, when 3 children were during the morning assembly in a school in Kerala, 3 children stood respectfully during the national anthem, but did not sing the national anthem. There was an MLA in the audience, and the MLA went to the assembly and asked that these children be penalized. The children's parents went to court and said that they, as Jehovah's Witnesses, were not permitted because of their religion to sing the national anthem. The court actually ruled in their favor, quoting Article 125. This is what the court said, and I'll conclude on this. Article 25 is an article of faith in the Constitution, incorporated in recognition of the principle that the real test of a true democracy is the ability of even an insignificant minority to find its identity under the country's constitution. This has to be borne in mind when interpreting Article 25. The court ruled that it was unjust to penalize the children. Does the Swiss case look like the Kerala case? Is it the same? Are there fine principles involved? These we need to debate. And we can only debate this if we recognize that minority rights, as it has evolved in India, constitutes a great resource. I make this comment because I'm directing it to our own internal audience. Thank you.